Now, if a court finds that your right to fair trial, unlike any other right, is violated, the recourse or the effect of that is that it is as though the action that was taken has been completely undone. It is as though it was not taken in the first place. Because all the other rights, Jesse, all the other rights under the Constitution lie and find their lives on the right to fair trial. It does not matter whether heavens fall. In fact, Jesse, on that right, a 5-judge bench already found that even in a case of terrorism and state of emergency, the right to fair hearing cannot be derogated. So what we saw today is what I would call 3 judges sitting as morticians to a right that you cannot touch. They pose a justification and they say that were they to find that the effect of Rigathi Gachagua not being heard would undo or quash the entire process of the impeachment, then we would end up with 2 deputy presidents and what they call a constitutional crisis under Article 145(7). Now, Jesse, Article 145(7) says that the finding of the Senate as to an impeachment of a president or a deputy president is final or shall be final. That finding of the court shall be final. And therefore they say, we found your rights to have been violated. Instead of undoing the entire process, we award you 50 million. If you read 145(7), the finality of 145(7) is the finality as to the merits. That if the Senate so wise that they would impeach Rigathi Gachagua for violating certain principles, that right is absolute to them on merit. But where there has been a constitutional infraction, nothing stops the High Court from adjudicating and undoing that violation. Rigathi Gachagua in his amended petition already told us, I am not seeking for reinstatement. And that is why I'm here saying, we may not like Rigathi Gachagua, but we cannot butcher the Constitution in the manner the 3-judge bench did today. Because the next time, Jesse, the next non-derogable right, let's say the right not to be subjected to torture, will be violated by a state agency. And the court will use this precedence and say, look, although the right to fair hearing was non-derogable, the court awarded 50 million. Although you were tortured, let's say the police were looking for evidence to charge you, all we can do is to compensate because the crime that is before you or the crime that you have allegedly have committed is very serious. That is where the court has put us. On the afternoon Rigathi Gachagua was to be impeached, Rigathi Gachagua fell ill. Now, the peculiarity of this, how peculiar this is that Rigathi Gachagua had no other witnesses in this matter. He was the sole witness that could attest as to the gravity of allegations and could face trial. Now, 2 things happened. The court does a very good analysis and say, all the senators who spoke that afternoon did not contest that Rigathi Gachagua was unwell. In fact, they wished him well. The speaker in the final communication when he was declining the adjournment told us that we wish Rigathi Gachagua well because health is beyond any human circumstances. But number 2, the Senate had proceeded on the premise that they have 10 days. So even Saturday was available to them. Senior Counsel Paul Muite asked the House, why then can you just consider my client and give me a little bit more time and see if my client will get some relief? So it was not a violation where you say there were other witnesses to be able to speak on behalf of Rigathi Gachagua. But he was the only witness. That is why I'm saying this is not about Rigathi Gachagua. This kind of mortalization of the Constitution cannot be available. And let me just finish on that by saying, if at all the grounds will fail, this single ground of appeal I am sure in my mind, will succeed. The court began on a very good footing. If you followed, the first issue that was before the court was, do you have jurisdiction to entertain an impeachment and be able to scrutinize an impeachment?
He said yes.
The court answers to the affirmative, and the court says, we do have that jurisdiction, provided that a claim on a violation of a constitutional right or the Constitution has been presented. And on that premise, the court says, we take jurisdiction. But the court did not stop there. The court goes ahead and says, we will not delve into the content or the merit of the impeachment. And if you recall, Senior Counsel Elisha Ongoya during the trial made extensive submissions on each of the grounds of impeachment upon which Rigathi Gachagua was impeached. The shares issue, the issue of shareholder, the issue of the comments against Justice Maina. But if you listen to the judgment today, the judgment did not delve into any of those issues because the court said we cannot engage with the content or the merit of the reasons why the Senate did that. All we can do is to ask, in the process of so doing, did the Senate step on any constitutional right? Now, upon making that very solid finding, the court then goes ahead and somersaults. This is all I call judicial acrobats. It somersaults and says, here is the most of the prime rights of an individual, the ones you cannot touch. Actually, they even say that it is one of the rights that even if he was the devil, please hear him. He may be the devil, you have decided you want to, kill him altogether or mutilate him, but hear him. So the court, having gone on that premise, the court then somersaults and says, here is a right that has been clearly violated, but will not intervene. The effect of that, which is what you have asked, is this. The effect of that is this, is that the court has used Article 145.7 to destroy Article 25, which is not permissible in law. You can't use one provision to destroy another provision of the Constitution. You can't say you will only get this right. The court essentially was saying you can only get your right to fair hearing and, vindicated in the right manner as to process, only if it is not going to lead to a scenario where we have two deputy presidents. Provided the court quashed the process, the consequential effect would have been that the entire process that led to his removal is gone. That can be interpreted differently. Some people have interpreted it that what it would have meant is that he gets back into office. But there are two issues. Today we have a substantive deputy president. All the court would have done on the first instance is to say, although we undo the entire process and its legal effect is Article 75.3, which says if you've been removed, you cannot run for a public office. The best the court would have done is to say, we do not reinstate you in office because another constitutional process, that of the appointment and the vetting, the voting on Kithure Kindiki, which they found to have been compliant and agree with them that the process was compliant, having taken place to its logical conclusion, all we can do is to make a declaration that Article 75.3, which tells us that if you have been impeached, you are not amenable to run for public office, cannot apply to you because the very substratum that led to the outcome is a nullity in law. So the court cannot even be heard to be saying that. But there is a second path that the court would have taken, even in the circumstances. Nothing would have stopped a court from saying, look, although it's disruptive, but it is possible because Article 23 of the Constitution allows the judge or the High Court to give appropriate reliefs in the circumstances. A party does not have to ask such reliefs when the court wants to fill some gap. The court would have simply said, look, the deputy president right now, Kithure Kindiki, is in office. But by the virtue of the quashing of your impeachment, you remain the substantive deputy president. Why? The deputy president, Kithure Kindiki, ought not to have been brought into office in the first place. That was a possible but a tricky route. So the second route becomes better. When Rigathi Gachagua came before this very bench and asked the bench, look, stop this process of the Senate from happening, because if it happens, it has a binding consequential effect. You might not be able to undo it.
This is when the impeachment was happening?
Yes.
Okay.
If you recall that ruling, this same bench was clear. The bench said, look, do not worry. Allow the parliamentary process to take its logical conclusion, because we will still be able to adjudicate and vindicate any constitutional infractions that come out of the process. The court assured Rigathi Gachagua during that time, and remember the stay was lifted, even in the final stay that was lifted that now paved the way for Deputy President Kindiki to be sworn in. They categorically said that. Today the court said, no, our hands are tied. Then you ask, if they knew their hands were tied, wouldn't it have been better then that at that time they preserve the quality of the Constitution by issuing the conservatory orders? But that's a different issue. To the Court of Appeal, two principal issues will dominate that court. The most glaring one is the one we have spoken about. The question of, are you able to find that somebody has been violated of his fair trial rights and then go ahead not to undo the process? Because the effect is natural justice. It is as though whatever happened did not take place in the first place. And now that Gachagua did not insist he wants to go back to office, who knows, even if the legal effect would have been for him to go back upon the Kwashi, he would say no because he dropped that choice. We would still be here with a constitutionally compliant country. So that is one of the limb. Are you able to restrict and derogate on a right that the Constitution says cannot be derogated? That would be one. And number two, and perhaps the most serious one, is Article 145(3)(b), where the court asked itself today, upon receiving the motion from the National Assembly, was the Senate to go plenary or was it to go through a committee of 11 members? The court says, we have looked at the history of Article 145. It begins from the Bomas draft, it goes to the Wako draft, and it comes to the final text that found itself within the Constitution. And says, look, our interpretation, looking at the history of this matter, is that first, the Senate ought to have a resolution. When it receives the impeachment motion, it needs to look at it on the face of it. Does it disclose some charges or some grounds that call upon us to have an intense inquiry, resolution stage? So if, for instance, the president is to be impeached for wearing a yellow shirt, and the Senate says, no, this is not a ground we cannot sanction, the motion should be able to die at resolution stage. But if the court found, like it did now, that the grounds are plausible, they can call for some intense scrutiny and inquiry, the may in Article 145, the problematic may in Article 145(3) turns into must. So it will depend on A. If the resolution does not approve the prima facie, the charges, it dies. But if it does approve, then it has a mandatory duty under B to come up with a committee. The court says, this is our interpretation. Then what the High Court does, it picks a Supreme Court decision in Sonko, and it says, no, Sonko said as regards to impeachment of governors that the Senate can go through plenary, that committee of the whole House, or it can go through the committee route. Then the court says, with utmost respect, we respect the Supreme Court. Although we have found that this is the right interpretation, we are bound by the finding of the Supreme Court. That is problematic in two aspects. One, the same court is saying the impeachment of governors is distinguishable from the impeachment of the Deputy President and the President. That's the first problem. The second problem, they say that Article 145(3) is the same as what the Supreme Court was interpreting, Section 33 of the County Governments Act. The problem is, the Supreme Court, what was before the Supreme Court was not what is the interpretation that should be ascribed to 145(3)(b). It is what in law we call obiter. Obiter is just those passing statements that a court can make in the process of adjudicating the main issue. Like today, you had the court say, let the National Assembly or the Senate pass this, kind of bill. It does not form part of a binding because, the court has no way of enforcing it.
Okay.
So there are those orbit and then the main holding. So those two issues will actually be of great interest, amongst others. Okay, you see, this is not something open to interpretation because Article 99(3) is clear. I've seen some people say that Article 99(3) only applies to members of parliament, but that is an erroneous reading. Indeed, it talks about a member of parliament. But remember, the same constitution says, if you are to be eligible to vie for presidency, you must qualify as a member of parliament, which means Article 99(2) and 3 applies in the similar manner because IBC must first ascertain that you are qualified to run as a member of parliament. That's when you will be cleared to run for presidency. So in this case, even if the appeal at the Court of Appeal is fast-tracked and the Court of Appeal agrees with the three-judge bench, which is unlikely in my view, but in the judicial process, it's a matter of you never know, wait and see. If they do that, and Rigathi Gachagua appeals further to the Supreme Court, I can guarantee you that if he wants to run in 2027, he'll be on the ballot. Remember BBI? The Supreme Court told us you cannot sue a president, a deputy president, under any circumstances, whether in a civil process or in a criminal process. So even if somebody wanted to go to court to challenge his occupancy of office, he'll not succeed because you cannot sue the president as a personality, as an individual.
What if he's given the running mate ticket? Can you sue the deputy president?
Well, that is still not clear because you see, the Supreme Court in BBI tried to avoid that question. They tried to avoid that question. But then they say what is not expressly provided is excluded. So there is a possibility. What is not expressly provided is basically excluded because the Constitution only refers to the president. And this is what you call a pendulamic judgment. A judgment that even those who are following, it swings far left and you think you are almost close to heaven, and then it returns you to the earth and back again to, like I was saying, the former deputy president was swinging between Wamunyoro and Harambee Avenue and IBC officers in Nairobi for clearance. I think it has created a lot of confusion. You need a judgment that is internally coherent for such a serious. So, because you see, there is also the place of public perception. There is somebody who was watching that and, is listening and is saying, oh, your rights have been violated, but we are sorry, we cannot undo the process upon which, you are meted such kind of actions. So I think my short answer would be, today, there was no justice. And like I said from the beginning, this was a clear butcher of our Constitution. I think we must not allow our Constitution to be butchered in such a manner that the three-judge bench did.
Yeah.
If you look at the manner in which the question of public participation was handled, and with utmost respect to the court, I think the court did a glossy kind of analysis where it does not want to deal with the real issues that were presented. Remember, there were affidavits before the court averring that there were bribery allegations of close to 10 million before this bench. You realize that the manner in which the court was dealing with the matters before it, the court was being too careful for itself. And you'd see that through every analysis. They set out the law, they say, this is what the law does, and then when they get to the facts, they avoid the germane issue. So the question of public participation, for instance, especially on the quantitative aspect, because there is the two sets, there's qualitative and quantitative. The court says 200,000 against the 55 million is sufficient public participation. However, for public participation, I will not blame the three-judge bench. I have always argued that the Supreme Court indeed gave a lot of power in the Okiya Omtata judgment on the finance bill. It gave a lot of power to parliamentary organs in terms of, the leg room of what they can, how far they can go in determining the issues of public participation. So I think perhaps this court was also just trying to apply the same to what was before it.
Okay.
Apart from the question of public participation, you recall that there was a very critical issue. The court says we cannot delve in merit. You recall the Mwangaza, the Kawira Mwangaza judgment. Justice Mwamuye told us nothing stops you from delving into the merit, whether the charges were rightly framed or not. And the Court of Appeal, the same in Wambora, told us that. So I can assure you, I can guarantee you, perhaps the only question that will not make it on appeal is the question of perceived bias and the question of jurisdiction.
But the others will.
The others will. All the other grounds will.
And they'll be weighty.
And they will be weighty. But the two most consequential one would be the one on fair trial and the one of Article 145. Committee or plenary route.